Biafra will come. You either allow us to go in peace or you are going to remain pieces and Biafra will still go. And you see this thing we are asking now, that you must recognize the Biafra referendum. It is going to end in the round table when the stupid and foolish ones have died in Biafra land. Many of those terrorists they are sending, they are going to die, all of them in Biafra land. You cannot just come to kill us and we watch you and fold our arms to watch you kill our women and children. It's not possible. So you will die in Biafra and your spirit will never be alive to witness the round table discussion of how they are going to accept the referendum of Biafra and how Biafra will come, because it is going to come and it is going to happen. Everything happening today will end up in a round table, and we have prepared for that. I am telling you. But you see,
welcome, fellow Biafrans, lovers of freedom. I welcome you to this amazing platform once again, and I wish every one of you a very happy new year. We are now in the year 2025. This is the platform that belongs to the United States of Biafra, and in here we bring information that has to do with the United States of Biafra, information that are coming from the office of the Deputy Prime Minister, Dr. Ngozi Orabueze. In this platform, we'll say things the way they are. Please like and share these videos to all platforms, share to family and friends, share to everyone that you can get to, so that this information will sink in, because it is very important. The case of Mazi Nnamdi Kanu has continued to linger. We can do nothing than to watch and listen. We know that the freedom of Mazi Nnamdi Kanu will come through the effort of the Biafrans and not what the court are saying or what the politicians are doing in Nigeria. We have said it time and time again, and that is the only truth. Let us watch and see their debate going on in the case of Mazi Nnamdi Kanu. Even we know that they cannot set him free except we do extraordinary things. Let's watch and hear the debate.
Now, Nnamdi Kanu, the leader of the indigenous people of Biafra, IPOB, has offered a 1 million naira reward to any Nigerian law student who can find a judicial precedent where a Nigerian judge granted a stay of execution in a criminal case involving an acquitted defendant. The IPOB leader made the pledge following a stay of execution granted to the Nigerian government in October 2022 by Justice Haruna Samani of the Appeal Court on a judgment which was also delivered by Appeal Court judges, which set Khan free and acquitted him of charges of terrorism and treasonable felony against him. According to the IPOB leader's legal team, throughout the period of what they described as a mock trial before Justice Binta Nyarko of the Federal High Court and the Court of Appeal, no decision of the courts touched on the merits of the case. A three-man panel of justices of Appeal Court had held that extraordinary rendition of Kanu by the Nigerian government without adherence to due process of the law was a gross violation of all international conventions, treaties, protocols, and guidelines that Nigeria is a signatory to, as well as the breach of the appellant's fundamental human rights. The legal team of the detained leader of the indigenous people of Biafra, Nnamdi Kanu, led by his special counsel, Barrister Aloy Ejimako, has alleged that there is an unholy alliance between the Nigerian government prosecution and the judiciary on Kanu's terrorism treasonable felony trial. Kanu, who has been detained by the Department of State Services, DSS, since 2021, on a terrorism charge, made the announcement through his legal team. Oh, well, we still have in the studio here Barrister Asim Adam, a lawyer and a political affairs commentator. We also have Mr. Dele Fanimo, who is a seasoned reporter and VOP in-house analyst. Gentlemen, thanks for staying with us.
Thank you very much.
Barrister Adam, this falls within your forte. Let's speak law before we now get into the politics of everything. Now, Nnamdi Kanu is offering a 1 million naira reward to any law student. I don't know why he restricted it to law students. He didn't include lawyers, you know, because lawyers are the ones who understand precedents and all of that. Referring to, and in the other section of section this and that, why is he asking for, you know, a precedent? Is it clear to him that there is none in our legal books, in our statute books? I want to find out from you. Can you walk us through what actually led to him asking for a president to defend his case?
Excuse me. You know, I understand the feelings of Nnamdi Kanu and his camp. I also understand the feelings of his supporters and those who are for him and his legal team. You know, we are lawyers. In our various matters, etc., as the case may be, we express sentiments, some real, some not real. It is trials, like Nnamdi Kanu's case. It reminds me or reminded me of, you know, the trial of Kenule Sarowiwa, otherwise known as Ken Sarowiwa. In 1995, I was just a very young lawyer, just leaving the law school some years. So I followed that particular trial of Ken Sarowiwa with emotions. And I found out where I wept that day was the day Gani Fawayemi, the legendary Gani Fawayemi, wept in front of that panel or tribunal and withdrew his services for Ken Sarowiwa. That tribunal later went on to convict and sentence him to death by hanging in what is already regarded as the Ogoni 9, debacle. A lot of things went on. It was a similar trial, convoluted, just like the one you have with Nnamdi Kanu. Now, in the case of Nnamdi Kanu's trial has been convoluted. For me, it's been nauseating anyway, and I can feel his pulse. I can feel the pulse of the lawyers who are working for him. Now, the question he asked is that whether is it stay of execution also, whether it will apply, where somebody has been, discharged but not acquitted, or discharged and acquitted by, the Court of Appeal. Now, you see, we in our legal, jurisprudence, criminal one for that matter, we have precedents. We have, a road. Let me use the word, a road that we have to follow. We have laws, guiding. Now, an armed robber has been executed. Has been found guilty. I'm not talking about Nnamdi Kanu for this. I'm using from the example. The lower court found, and maybe an armed robber should be set free. The armed robber has been discharged. But the moment the person, they are to fulfill formalities of his being taken out of prison or from that courtroom, you now see the other party, drop a notice, either of appeal against that particular judgment. Accompanying that notice of appeal is a stay of execution of that particular judgment that was given, by the lower court. You understand? Our president allows that. So if you are able to move the appellate court to stay execution of what that particular lower court gave, pending whatever, that other person will remain in that status quo as a man that has been, discharged but has not gotten his freedom, pending the appeal before the appellate court. But in this case of Kanu Nwankwo, I have not really read, the submission of his lawyers, whether it was an appeal. There was a notice of appeal by the federal government to the Supreme Court, appealing or trying to notify that they are going to appeal the discharge of Nnamdi Kanu, and now asking that that particular order given should be stayed. They have the right to do that under our legal jurisprudence. Okay. It is a right that is intrinsic in all parties to a suit, whether it is federal government or anybody at all, as case may be. They have the right, to file that notice of appeal and get a stay. If the court grants a stay, then it goes. A stay of execution can be brought before the particular court that gave that order to stay that particular order the court can give that order. If the court refuses to give that order of stay of execution of a particular judgment they give, then you go to the appellate court, which is the court of appeal. And if that is given, I think it's...
let me stay with you. I'm not a lawyer, but yes. I also understand some of these procedures. And I know what happened in this case.
Yes.
Now, Nnamdi Kanu was renditioned from Kenya and brought to Nigeria here. They sent him to court, you know. I think, how many count charges? I can't recall.
There are so many.
There are so many of them.
Withdraw,
but what happened? It was not, I'm not sure it was an issue of withdrawing and bringing more. What happened was that at the appeal court, the court clearly said that, look, Nnamdi has no case to answer.
Yes.
Because in the first place, he was illegally renditioned, brought back to Nigeria against international treaties, conventions, to which Nigeria is a signatory to.
Absolutely.
Now they discharged him. Instead of the court to release him, instead of the DSS or prison, the custody where he was to release him, federal government didn't allow that. They now brought fresh charges against him. So I want us to understand, is that allowed? Because it had been discharged based on the charges that were filed against him. The court said he had no case to answer. But the court, the federal government, through the Attorney General, now slammed fresh charges on him even before releasing him. Is that proper within the legal spectrum?
Well, you know, we are on national television. Okay. I think what we need to do is that before I can answer that, I need to get my facts very correct on the issue of Nnamdi Kanu discharge. Because if you there are two things involved here.
Okay.
Being discharged is different from being discharged and acquitted. I don't know if you understand.
Yes, I do.
Now, if you are discharged and acquitted, you understand the point now? You are supposed to go. Then it's an appeal that the other party can go to. That is, the state can go to now to reverse that particular judgment. Now, if you have been discharged but not acquitted, I don't know if you are getting me. If you have been discharged but not acquitted, the state can still prefer charges against you. You understand? That is what they did in the scenario you gave.
Okay.
You understand? I don't know if that is what applied in the Nnamdi Kanu's case. If you are discharged, let it get me very clearly. If you are discharged but not in a criminal case, for you to go home and go and sleep with your two eyes closed, you have to be discharged and acquitted. But the court will say you have been discharged. And when they say you have been discharged, either the procedures that the police or the prosecuting authority followed were incongruent with the law. So that is what we call technicalities. The court will say, no, police, because of the fact that you did not issue a warrant of arrest or search when you went to that man's house or you arrested him, the offense prescribed that for you to arrest him, you have to issue a warrant of arrest before you can arrest. But before us, we don't see anything like that. So based on that, the lawyer has raised valid point on section this, that, as case may be. Based on what the lawyer has raised, you have been discharged. But that does not mean that you didn't commit the offense that you'll be brought to court for. You are being discharged because of technicalities in the sense that they didn't follow due process. Let me use the word due process to bring you before us. You understand? So, but when the case is gone through its merit and gamut without technicalities, and they now say, you committed this offense, it means that, or you didn't commit this offense. The court will say, please discharge and acquit this guy. Discharge, acquit, free of all those offenses. And once you have been acquitted, of any offense, when you be discharged and acquitted of any particular offense, they cannot bring fresh charges bordering on the same charges that you have been acquitted of. You understand the point now? So these are things that are very, very clear. They are very technical explanations that we need to let people know. So in the Nnamdi Kanu's case, that's why I said I need to, because when you brought up this topic now, I cannot make an informed opinion on, periscoping Nnamdi Kanu's case, what happened in his case, and why the lawyer had to raise this particular, voice right now. Now, I will look at it and maybe come back, but I'm looking at law generally. That in the case of Nnamdi Kanu, was he discharged and acquitted? These are the questions I want to ask. If he has been discharged and acquitted, it then means that no particular authority can bring fresh charges against Nnamdi Kanu in that particular case. They can only go on appeal.
All right.
Do what now? Arrest that particular, judgment that was given in favor of Nnamdi Kanu. Okay. But if he was discharged, and say he has been discharged, as he's leaving we have seen it happen.
They will arrest him.
As he's leaving the court premises, and it has happened a number of times before me. Well, a stay of execution. A stay of execution has a, kind of, it's not an infinite, life span. You know that, let me give you an example now. If I get a stay of execution of a particular action, I have to quickly run to court. We don't waste time. As lawyers, you have to, once I get a judgment again, in fact, when we are going to court, we begin to prepare our notice of appeal and, stay. Alongside motion for stay of execution in case that matter goes against, the judgment goes against us. So we now find out that the moment they realize the judgment and we find out that, we are not satisfied with what the lower court gave, we just quickly file our notice of appeal and file our stay alongside etc. as the case may be. Now, like I said, I can file my stay in the same court that gave, that particular judgment. If maybe it's a high court, I can file that particular stay before that particular high court, while I do my notice of appeal, as case may be. Okay. If they reject that particular motion for stay, then I have the right to go to the court of appeal to obtain a stay of execution of that particular judgment. Until that particular stay is granted, either by that court that gave that judgment or the appellate court, until it is granted, I have the right to do whatever I move around. If, for instance, I'm a criminal, or maybe we have the land matter, I have the right, to move. Something happened yesterday at the Federal High Court where I was. A particular judge gave a stay of execution of a judgment that was before it. What happened was that during the pendency of that particular stay, immediately they got that particular order, stay execution, what the people did, they had to go and demolish and all those things. Okay. You understand? So they took that act and the court frowned at it and said, why? The law was said, no, if you have stayed the execution of judgment as the case may be, I have the right to do anything I want to do on that. So it was a technical kind of argument. So in this Nnamdi Kanu's case, let us be very careful. We need to be and be seized of facts, before we take or make an informed position on it. Okay. As the case, I read the body of this thing, but I have not really gone to read, the facts and the judgment of court, pertaining to Nnamdi Kanu. People keep saying he has been discharged. Being discharged does not mean that you are free of the charges that the government also have or the allegations against you. You must have these two together. Yes.
Yes. It was in October 22, and the case was, and the appeal court was decided by Justice Haruna Sama. Okay. Clearly, Nnamdi Kanu was discharged and acquitted.
He was discharged and acquitted? And
acquitted.
Is there on record?
Yeah, it's on record. Okay. But what eventually happened is that, look, the government slammed fresh charges on him. Now, I want to ask you, Dele, does it look like, Nnamdi said that there is some kind of unholy alliance between the Nigerian government and the judiciary. If, based on the explanation given by Barrister Asim, do you see some kind of politics I'm not talking about the politics of the Nnamdi Kanu, his detention and all of that. Does it look like there's politics in his prosecution, in the process of prosecution? But based on what the barrister explained.
Well, I'm being a little bit circumspect here. Okay. Because I am not a lawyer. Okay. And I don't understand law as much as
the barrister.
A barrister. But you see, even in our various zones, even when we are taking decisions, there is a political twist to our decisions. Even in our home, we play politics with our children.
Even in workplaces.
Even in workplaces, there is high-tech politics in workplaces.
High wire.
Yeah. So, to this extent, I will say that, of course, there could be political undertone to all this. But the point is, in the chessboard, the game is always who holds the trump card, and who holds the trump card would want to use it maximally, and in the course of doing this, there's always an interplay of politics. So for me, you can't rule out that. And Buhari was in the saddle when he was picked, and he may have his own intention for picking him. And now it's been inherited by Tinubu. So, but the point I want to make outside of the courtroom is that that statement couldn't have been, that statement, for me, we wouldn't sit down with some lawyers. If you have sons prosecuted your case, and now giving 1 million naira to law students, it shows you have lost confidence in those lawyers. But now, by implication.
But Mr. Fanimo, the way this whole matter has been going all this while, the back and forth by the federal government and all that, even when he was discharged and all that, and how it's moving with Binta Nyako issuing recusing herself from the case, and federal government bringing her back to the particular case. She says she's not interested in anymore and all that. Don't you think it's high time we spread the tentacles, or rather Nnamdi Kanu and his counsel spread the tentacles to know if there are things that they are not aware of that other persons might know? The way the case is going.
It should have been in the realm of law students. It should have been in the realm of lawyers.
Okay. Before we run out of time, I want to pose this question to Barrister Asi Madams, and let's also correct the assertion. Nnamdi Kanu was discharged, not acquitted. Just to correct that.
Yes.
Now, in a situation where a judge recuses himself from a case and says, look, I'm stepping aside, can and should that judge be compelled to still sit over that case? And if that happens, what could be the modalities for such compulsion?
The moment a judge recuses himself or herself from a case, that should be obeyed. That is the decision. That discretion should be valid and obeyed.
Okay.
But if the CJ felt, because I've seen situations where you see the judge will say, no, I'm recusing myself based on petitions that have been written against me. I don't want my hands stained. But the agency or whoever the petition was sent to will go through the petition and say, no, we don't see anything in this. This is just mere whatever the case may be. You are still going to continue with the matter, because they don't see anything that is biased or impartial that you are going to display.
So that judge can be compelled.
You understand? So the judge is another given to the judge by the CJ. The CJ is the head of the judicature, as the case may be. So if he says you have to do this, there's a petition. Why do you want to recuse yourself? Say because the person on the other side is my relation. They will say, okay, no problem.
Okay.
But when a petition is written against a judge that he has to recuse herself, and the judge now says, based on this petition, I think I don't want any controversy here. I am recusing myself. He now sends the file to the registrar to send to the CJ for reassignment. The CJ might sit in and say, no, you are the proper person for this particular whatever the case may be. I don't think this petition, whatever it says, has any value.
So in the case
you
of
understand?
Nnamdi Kanu, which is playing out now?
Now, for me, that's why I said the Nnamdi Kanu's case. See, we have to be very careful. You understand, and analyzing the case, because we are on a national television.
Yeah.
Now, why am I saying that? And I have said before that from day one, if we follow what the technicalities of law is all about, Nnamdi Kanu ought not to be tried in the first instance. Or even if he's tried, he ought not to still be in custody or whatever by now. It's either you have sentenced or convicted him and sentenced him to how many years or whatever the case may be, or he walks free as a free man. But our judicial system grinds slowly, even slower, like the Russian locomotive. You understand the point? And so, because of that, you find out that a matter has come before this. It goes up and down and all these things. Before you know, people begin to think so many things. I want to give for an example. My chambers in Lagos here, we have about 7 cases before the Supreme Court. As I speak with you, we have not even gotten a date. And you find out that these people, the litigants who are there, for years they have been waiting. When you come, they say, we have not, Supreme Court has not given us a date, wait for us. They begin to get tired of the system, as the case may be. It's the same thing. The reason why you are seeing these speculations here and there about Nnamdi Kanu's case is because of the fact that the matter has lingered for too long. It has become a convoluted, legal trial, as the case may be. So now, like I explained before, if Nnamdi Kanu was discharged, the layman will go to the street and say he has been released free to go. Technically speaking, yes, he can move on. But he may get to his house and the next day they pick him up again. You understand?
Yes.
And say, no, we have brought fresh whatever against it. They take him to court again. He begins another trial, a new one again. But if a court now looks at the case on its merits, he now says, no, this man did not commit this. He has been discharged this man and acquit him.
Okay.
The state, I'm making it fast because people
cannot try him on that same
the
case
state
again.
cannot bring fresh charges against him having been discharged and acquitted. They can only appeal against that particular acquittal and discharge.
Thanks for
so they
making
will
that,
bring this is anathema. Maybe that is what happened in the case that he has been discharged and acquitted, which I can't say for now. And they now say they are bringing.
We are saying that he was discharged, not acquitted.
He was discharged, not acquitted. So the state can still bring it
because of time.
May Chukwu Okeke continue to guide our Prime Minister Mazi Nnamdi Kanu. May Chukwu Okeke continue to guide our Liberation Army. Biafra government, peace, progress, unity and equity. We move airborne